Yo, what's up, man? Shout out to the people. Welcome to the podcast with Soul. Got the dope coffee. The dope coffee. Went and bought some new creamer today. Went and bought some new creamer with no added sugar. No added sugar, so I could stay ripped up. The reason I'm making this video is I want to show you what justices on the Supreme Court, 3 of them, primarily a female judge, Justice Sotomayor, Latina, Kavanaugh, and Gorish, I think his name is. 3 United States Supreme Court justices. I'm gonna show you what they feel about using acquitted conduct in the sentencing, which is what the judge, the new judge, the beginner judge in the Puffy trial precisely did, violating Amendment 826, justifying his enhancing Puff and using acquitted conduct, and verbally comes out and states it, that he's using acquitted conduct under Rule 3661 and 3553A. This is the judge. This is his name. Indian judge from India. He asked both the defense and the prosecution to bring him back cases 18 USC 2421, 2G1.1, with a criminal history category of 1. This is his order. When you do that, what he said, you come back with a base offense level of 14. Category 1, base offense level 14. 15 to 21 months. At the sentencing, and all of this stuff is public information. You can get all of this on pacer.gov. You got to pay for it, but you can get it. This is Judge Submaranian. Mr. Combs was convicted of 2 counts of transportation to engage in prostitution under 18 USC section 2421, which is what I just showed you, 21A, each of which is punishable by not more than 10 years of imprisonment, 5 years to a lifetime of supervised release, and other monetary penalties. The PSI, the pre-sentence report, reflects an offense level of 27 and a criminal history category of 1. I have reviewed the PSR. I now calculate and find that the defendant's offense level is 27 based on the analysis above that I've given and the findings that I've made, including the factual findings in the pre-sentence report. The court, meaning himself, I agree with the probation department's calculation of the offense level for each group as well as the number of groups. So the offense level is 27. The defendant's criminal history category is 1, and as the defendant has 0 criminal history points, an offense level of 27 and criminal history score of 1 yields an advisory guidelines range of between 70 to 87 months of incarceration. So, a base offense level of 27, he enhanced Puffy from a 14 to a 27, 70 to 87 months. He got that enhancement using acquitted conduct that the probation department put in the PSI, that the Southern District of New York prosecution and the United States attorney calculated in their sentencing guideline calculations. They used acquitted conduct. The probation department used acquitted conduct. And the judge agreed with the use of acquitted conduct in determining the sentencing guidelines. That is clearly against the law as found in Amendment 826, United States Sentencing Commission, Amendment 826. Acquitted conduct. Relevant conduct does not include conduct for which the defendant was criminally charged and acquitted in federal court, unless such conduct also establishes in whole or in part the instant offense of conviction. So what he's trying to play is that the acquitted conduct, which he cites in this sentencing hearing, coercion, fraud, and force, that the jury rejected. The jury acquitted Puffy of coercion, force, and fraud. But Judge Submaranian said, fuck that. We're going to use coercion, force, and fraud in this sentencing. And the Southern District of New York probation did the same thing. Southern District of New York probation, Southern District of New York prosecutors who lost that trial, Southern District of New York employee, Judge Submaranian, all of the Southern District of New York, all agree that they're going to use force, fraud, and coercion to enhance Puffy 13 levels. First offender. First offender with no criminal history gets enhanced 13 levels. Is there some discrimination going on here? There was a case called the United States versus McCLINTON, or McCLINTON versus the United States, where a 17-year-old child, Deontay McCLINTON, him and his friend robbed a pharmacy, got away. There was a dispute over how they were going to share the proceeds from the robbery. Deontay McCLINTON's friend ends up dead. He gets busted, found, charged, indicted, and he's indicted for murder of his friend, and he's indicted for robbery of the pharmacy. He goes to jury trial. I make the best coffee. My coffee better than your coffee. You don't make coffee as good as me. Check my coffee out. He goes to trial. The jury acquits him of murder. They say, nah, not guilty. But they convict him on the robbery of the pharmacy. Cool. When Deontay goes to sentencing for the conviction of the robbery of the pharmacy, the federal judge, when his sentence should have been 5 to 6 years for the robbery, the federal judge uses the acquitted conduct of the murder of his friend to enhance him to go from a sentence of 5 to 6 years for robbery to 19 years, 3 times the sentence he would have received based on acquitted conduct. A jury found Deontay McCLINTON innocent of the murder. Yet, when he went for sentencing, the judge used that conduct to enhance him from a 5 to 6 year sentence to a 19-year sentence. Deontay appealed to the United States Supreme Court. The Supreme Court denied to hear the case. They didn't hear the case. But when Supreme Court Justice SOTOMAYOR read the case, she offered an opinion. Let's check it out. Supreme Court of the United States, Deontay McCLINTON versus the United States. On petition for writ of certiorari to the United States Court of Appeals for the 7th Circuit. The petition for a writ of certiorari is denied, meaning that they didn't want to hear it. Statement of Justice Sotomayor respecting the denial of certiorari. Check this part out, y'all. Check Sean G out. The prosecution in this case argued that Deontay McCLINTON, then 17 years old, shot and killed his friend in a dispute over the proceeds of a pharmacy robbery. The jury unanimously acquitted him of killing his friend and convicted him only of robbing the pharmacy. After that, however, something happened that might strike the average person as quite strange. This is Justice Sotomayor, Supreme Court. At McCLINTON's sentencing for the robbery conviction, the prosecution again argued that McCLINTON had killed his friend. So at the sentencing hearing, the prosecution is still on it. He killed his friend. He killed him, man. He killed him, even though the jury acquitted him. When the judge agreed with the prosecution, this caused McCLINTON's sentencing guidelines range to skyrocket. While the ultimate sentencing decision is discretionary, the guidelines are the framework for sentencing and anchor the district court's discretion. McCLINTON's guideline range had initially been approximately 5 to 6 years. Yet, taking into account the killing, the judge sentenced McCLINTON to 19 years in prison. As many jurists have noted, the use of acquitted conduct to increase a defendant's sentencing guidelines range and sentence raises important questions that go to the fairness and perceived fairness of the criminal justice system. These concerns arise partly from a tension between acquitted conduct sentencing and the jury's historical role. Juries are a democratic institution called upon to represent the community as a bulwark between the state and the accused, and their verdicts are the tools by which they do so. Consistent with this, juries were historically able to use acquittals in various ways to limit the state's authority to punish. With an acquittal, the jury, as a representative of the community, has been asked by the state to authorize punishment for an alleged crime and has refused to do so. This helps explain why acquittals have long been accorded special weight, distinguishing them from conduct that was never charged and passed upon by a jury. This special weight includes traditionally treating acquittals as inviolate, even if a judge is convinced that the jury was mistaken. So even if Judge Submaranian thought that the jury didn't get it right, he does not, under his own volition, can independently solitarily make the decision that fuck what the jury said. I'm going to use this acquitted conduct. He used force, fraud, and coercion, which is what he did. In contrast, there appears to be little record of acquitted conduct sentencing before the 1970s. The argument for acquitted conduct sentencing is generally based on standards of proof. A sentencing judge makes findings by a preponderance of the evidence, whereas a jury applies a higher, beyond reasonable doubt standard. So, preponderance of the evidence is just you hear evidence and you kind of feel like, oh yeah, he guilty or he's innocent, like what y'all do in YouTube land in the comment section. That's a very low standard. Juries are required and are held to a higher standard, beyond reasonable doubt, because an acquittal could reflect a jury's conclusion that the evidence of guilt fell short of the beyond the reasonable doubt standard. The argument goes there is no conflict with the judge making a contrary finding of guilt under a lower evidentiary standard. Yet there is a tension between this narrower conception of an acquittal and the manner in which juries historically used acquittals. A jury trial. This was a case, Blakely. A jury trial is no mere procedural formality. A jury trial is a fundamental reservation of power in our constitutional structure. Further, an acquittal could also reflect a jury's conclusion that the state's witnesses, the Southern District of New York's witnesses, were lying and that the defendant is innocent of the alleged crime. In that case, it is questionable that a jury's refusal to authorize punishment is consistent with the judge giving the defendant additional years in prison for the same alleged crime. The fact is that even though a jury's specific reasons for an acquittal will typically be unknown, the jury has formally and finally determined that the defendant will not be held criminally culpable for the conduct at issue. So far as the criminal justice system is concerned, the defendant has been set free or judicially discharged from an accusation, released from a charge or suspicion of guilt. There are also concerns about procedural fairness and accuracy when the state gets a second bite at the apple with evidence that did not convince the jury, coupled with a lower standard of proof. Go ahead, Sotomayor. Go ahead, Sotomayor. Que vive Puerto Rico. O coquí, chupicabra. Que vive Puerto Rico. Even defendants with strong cases may understandably choose not to exercise their right to a jury trial when they learn that even if they are acquitted, the state can get another shot at sentencing. Finally, acquitted conduct sentencing also raises questions about the public's perception that justice is being done, a concern that is vital to the legitimacy of the criminal justice system. This is also true for jurors themselves. One juror, after learning about acquitted conduct sentencing, put it this way: "We, the jury, all took our charge seriously. We virtually gave up our private lives to devote our time to the cause of justice. What does it say to our contribution as jurors when we see our verdicts, in my personal view, not given their proper weight? It appears to me that these defendants are being sentenced not on the charges for which they have been found guilty, but on the charges for which the district attorney's office would have liked to have had them been found guilty of. In this nation, juries have historically been venerated as a free school to which each juror comes to learn about his rights." The Supreme Court's denial of certiorari today, meaning what she's saying is, because the Supreme Court is choosing not to hear this case, the Supreme Court's denial of certiorari today should not be misinterpreted. The Sentencing Commission, which is responsible for the sentencing guidelines, has announced that it will resolve questions around acquitted conduct sentencing in the coming year. If the commission does not act expeditiously or chooses not to act, however, this court, the Supreme Court, may need to take up the constitutional issues presented. That was Justice Sotomayor's position on acquitted conduct sentencing. Statement from Justice Kavanaugh, with whom Justice Gorsuch and Justice Barrett joined. So 3 other Supreme Court justices agree. Let's see what they say. As Justice Sotomayor explains, the Supreme Court's denial of certiorari today, meaning the Supreme Court's denial not to hear this case, should not be misinterpreted. The use of acquitted conduct to alter a defendant's sentencing guideline range raises important questions. But the Sentencing Commission is currently considering the issue. It is appropriate for this court to wait for the Sentencing Commission's determination before this court decides whether to grant certiorari in a case involving the use of acquitted conduct. So, three more judges said that y'all need to check this out. Now, this is Justice Alito. Justice Alito dissented from these 4 Supreme Court justices, right? And I'm not going to read this whole thing because it's like 8, 9, 10 pages. See how big it is? I'm not going to read it. But there is something important that he said. In here, he says, number one, he says the same thing. He offers an opposite opinion of Justice Sotomayor, but then he leaves open the door at the end where he says, the fact that we didn't hear this case today, the fact that this court denied the certiorari, don't let that be misinterpreted. The same thing they said, that the Sentencing Commission needs to take a look at this. And then he said, the only reason I took an opposite position from these 4 was because for the record, I wanted there to be a contrary opinion. If the court, in some future cases, takes up the question of the constitutionality of considering acquitted conduct at sentencing, better arguments on both sides, meaning his side and Sotomayor's side of the issue, may be presented to us. And nothing that I have written here should be understood as the expression of a firm position on that question. But because my colleagues have laid out some of the arguments in favor of one side, I thought it appropriate to outline some of the countervailing arguments. What do you want from me? I'm just a YouTuber. I'm just a YouTuber and a window cleaner. What do you want from me? Free puff. Free puff. Peace.